That is the
Is it appearing in the list?
Appearing in the list, but the number is my lord.
number and name different.
Here is wrongly mentioned. And the cost
Can
type.
be taken up. Cost title wrongly.
No, not appearing together immediately after this matter.
Yes.
MAT 1382 is appearing in the list. Huh?
1382 appear করছে
কোথায় লিস্টে আছে? Yes, it is here.
there appear করে দেবো বাস ঠিক আছে my lord Rashid may kindly takes up and comes to the prayer in the writ
Appellant
petition.
there
Board.
in that matter. So there is a mistake, so no difficulty. No, once you are there, then no difficulty.
শুধু ইয়ারটা কথা বলতে পুরো টাচ হলো my lord before
Just
going
one
to
minute,
the
let us
impugned
go
order
to the impugned order first.
I'll be praying your lordship to see the prayers.
Yes, just 1 minute.
My lord.
Let us go to
Yes,
the
yes.
impugned order.
Kindly takes up the memo my lord.
Second judge's copy thou.
Starts for internal page 13.
You need not have to. Please just wait.
It's huge my lord. There are many appearances
Yes.
are there. প্যারাগ্রাফটা বার করে রাখ সদানন্দ হলো প্যারাগ্রাফটা বার করে রাখ প্রুভিং ইনকোয়ারি প্যারাগ্রাফ
This relates to what? There is already a
Amara-
CBI which is
Yes,
conducting.
it
earlier
is
order.
there. CBI has also given an affidavit saying that these cannot be. Kindly now takes up my lord my stay application. Page 46 is the prayers in the writ petition, and thereafter I'll draw your lordship's kind attention to the affidavit of the CBI. Thereafter order passed. Kindly comes to page 46. Writ petition, my lord, relates to a process of eligibility test conducted in 2014 and 16.
No, they wanted a supply of the OMR sheet.
Yes. That is the scope of the
That
writ
appears
petition.
to have been destroyed or something like that.
Now, my lord, kindly
In
comes
order
to,
retrieve it.
my lord,
Court has passed an order to retrieve it.
yes. Now, my lord, kindly comes to the CBI's affidavit, which is at page 50 onwards. This is the affidavit of the CBI dated 14 June 2024. No, not 14 June. This is affidavit dated 16th April 2024. Kindly comes to paragraph 16 at page 59. Lordship is at page 59, my lord. May I place the paragraph?
Just 1 minute.
এটা বের কর, মার্ক কর, মার্ক কর, মার্ক কর, এখানটা থেকে বের কর।
मोस्टली पानी है अंदर।
I'm praying for placing paragraph number 16. Now, my lord, paragraph 16, CBI says that they say that it has been destroyed. Now, my lord, kindly comes to page 149. This is the date when this affidavit was filed before the Honorable Trial Judge. Kindly comes to page 149. Here, my lord, the appellants before your lordships were added as party respondents. Paragraph 3, the Honorable Trial Judge records that CBI has filed this affidavit. Thereafter, at paragraph 6, the matter was fixed for, my lord, hearing. On 30th April 2024, when the matter shall be taken up for final hearing as specially fixed matter such and such, there will be no adjournments. We were ready to do the matter. Now, my lord, on 30th, kindly comes to the order which is passed on 38. It starts from page 158. The Honorable Trial Judge extends the period, my lord, several applications are filed, and thereafter the time to file affidavits is extended. Affidavit in opposition filed, my lord. Affidavit in opposition was also filed.
What is the division bench? This matter,
My lord,
Supreme Court directed this division bench to continue with the matter, which
no, this is not that matter. That is a different matter, my lord. That has been mentioned. Now, my lord, page 130, 163, my lord, the issues are fixed by the Honorable Trial Judge. The issues are starting from page 170 onwards. This order was subject matter of a mandamus appeal before your lordship. Your lordship was pleased to pass an order observing that the maintainability point has to be taken up fast. That is also annex matter. I'll be drawing your lordship's kind attention to that. But after that, when the matter is, my lord, ready for hearing and the affidavits have been exchanged, my lord, this order, which is, my lord, passed by the Honorable Trial Judge, was passed. My lord, kindly, my lord, this order was appealed against in page 189. This is your lordship's order of this honorable bench. This is arising out of the order dated 3/5/2024. And your lordship was pleased to, my lord, dismiss this appeal, observing that paragraph 13, we hope and trust that the point of maintainability shall be decided by the court of first instance as and when the same is raised or the occasion or to decide the same are before the dealing before such.
Arise before dealing,
Malad,
before
this-
delving upon to decide. the
Malad,
issue.
there is Malad, the
No, no, I can
printing
read it.
printing has not come in my Malad copy.
In my copy, at least you
I
can.
think it is legible copy which has been supplied.
Yes.
Now, my lord, at this stage, when the matter is ready for hearing, this order, in my humble submission, would amount to, my lord, roving inquiry and will be, my lord, hit by the principles of, my lord, this Sadananda. Hello, my lord, kindly seeks, my lord, I'm praying, I'm referring to this judgment, 2008 4 SCC 619. The matter may be taken up in its entirety, my lord. We are ready to do the hearing. Maintainability point may be thrashed out. It may go into the merits.
You are representing the set of the persons
Who had added.
who never participated in the examination.
No. We
but
participated in the
but
examination.
their name was shown in the.
No, nothing of that sort. That is, my lord, SSC matter. This is,
So
my lord,
here
different.
also, the-
These matters, my names have never
the
been shown.
CBI
Yes.
affidavit reveals certain facts.
We
I
are
have
not
read
those
from the
persons.
first paragraph to the last.
We are not those persons. We were, my lord, appointed much prior to this particular person who is named in the affidavit of CBI came into play. Entire thing he has done after, my lord, we have gone into the appointment. So, my lord, the appellants before your lordships are, my lord, persons who had come and said that whatever said and done might have been done after the appointment of their after their appointment, so they cannot be. That is on merits. That is the honorable trial judge will decide. My humble submission, my lord, kindly comes to page paragraph 58, my lord. My submission before your lordship is the subsequent order which has been passed even after the stage when the CBI has said that they have not been able to test out would amount to a roving inquiry which the writ court cannot do. May I just place one paragraph? It is settled
read-
law.
I read that.
Yes, paragraph it is settled law. But this is also in a recruitment process. There are several judgments to that effect, but I will not, my lord, pile of books before your lordship. My lord, only one judgment. That is why I am reading. It is settled law that in such writ petitions, a roving inquiry on a factual aspect is not permissible. Oh, achha. 84, page 619.
Yes.
The High Court not only engaged itself into a factual, not only engaged itself in a non-permitted fact-finding exercise, but also went on to rely on the findings of an amicus curiae, or as the case may be, the scrutiny team, which in our opinion was inappropriate. While testing the fairness of selection process, wherein thousands of candidates are involved, the High Court should have been slow in relying upon such microscopic findings. Here, my lord, the honorable trial judge is going to find out make out the microscopic findings, my lord. And my lord, it is not for the High Court to place itself into a position of a fact-finding commission. That too, more particularly at the instance of those petitioners who are unsuccessful candidates. Here also they are unsuccessful candidates, admittedly. The High Court should therefore have restricted itself to the pleadings in the writ petition and the say of the respondents. Unfortunately, the High Court took it upon itself the task of substituting itself for the selection committee and also in the process of assumed the role of an appellate tribunal, which was, in our opinion, not proper. Thus, the High Court converted its writ petition into a public institution without any justification. So, well, here also,
In what context it is used?
yes,
There, the High Court wanted to scrutinize whether all the marks which have been allotted,
Yes.
correctly allotted, or it is a correct one or not. In that
Yes.
perspective, this observation has come. Can it be applied in all conceivable situation?
then I can, my lord, find out. I have
The
those
decision,
judgments.
the decision is what it is decided in the perspective
Actual
of
background.
And then, my lord, I will come out with the other decisions also in
out with the other
different
decisions.
facts of circumstances. I will come out.
Because I have read this judgment, it was in that context because the High Court was entering into. the marks, allotment of marks, whether it is correctly allotted or not. That is not, I have also dictated today, I have said, no, you can't. Usurp the power of the academicians or the teachers who have the expertise in their respective fields.
Yes,
The
that
High Court
is,
should not,
now
unless there is a very
that is in
convincing.
the here also.
This is not a case. This is a case of a larger interest.
My lord, that is my
Now,
humble
let us
submission.
see,
This is, my lord, a case.
Mr. Gupta is also,
I can bring other judgments also in
Bring
this
it.
aspect.
that we will consider. Let it.
Then I'll, my lord, kindly keep it in next date. I'll bring other judgments also.
Your Lordship, kindly come to page 14 and 15. 6th of July.
Yes.
My Lord, there the court has said that any further investigation by the CBI through engaging other agencies, the cost is to be borne by the board.
Yes. You are concerned with the cost.
I am concerned with that. My Lord, investigation against me, I'll have to bear the cost.
Why not?
My Lord, is there
Why
any
not?
precedent
Why
anywhere?
not? You have no allegiance to anything. You are a neutral body. Your existence is because of the public and the citizens of the country
Of course, yes.
in the education system. Now, being a limb of the government, you are a limb of the government as well. If something is done, then who will bear the cost?
My Lord,
You
the cost, my Lord, in respect, my Lord, of every criminal offense. In respect of every criminal offense, investigation is carried on.
Come, I will consider your case. Very limited.
Lordship, there are 2 points. Lordship, in respect of
We wanted the resurrection of all those destroyed data. The court has said that there are certain mechanism where you can retrieve the data. You can retrieve, find out, take a help of any expert if you want, retrieve it, let it come. That is what the spirit of the order is.
My Lord, the board is not against this.
Lordship, second is, there were 2 aspects by of the honorable single bench by directing CBI over in respect of this particular directions, Lordship. One, as your Lordship has rightly felt it. The second one was, Lordship, if you can kindly comes to page number 15 of internal page number 15, paragraph 6C, where in absence of the scan copy of the images, what it remains is the what we call as the scanned copies or the digital data. Lordship, these digital data, what the CBI has indicated in their report or in their affidavit is that there were 2 set of scanners which were available with this agency while scanning the OMR sheets. One was the Seconic type printer scanners, and the other one was the ADF scanners. Now, the ADF scanners used to scan the image of the OMRs, and those images vis-a-vis with the answer string, if I may call it as, those were stored in an appropriate manner. Now, in this set, it has been admitted that the images were destroyed, but the scanned images, the scanned answer string, which were the output of the Seconic types, that were retained, Lordship. Now, what we have to bear in mind, Lordship, is that these second outputs were editable in nature, Lordship.
So that we have seen that it
Lordship.
is capable of being edited. That
Edited,
we have
Lordship.
said.
Paragraph 6C is basically direction upon
Understand
us
that is what he wanted.
is
that-
whether there were any manipulation or not,
Because if there is any editing which is done,
Lordship.
the software will indicate the date and the time of an edit. Are you aware?
Lordship.
If you go inside, if any editing is done, the software or the computer will indicate that what was the time, what is the date when the editing is done in the document.
Lordship.
There is no difficulty in retrieving those. If there is any
That is
editing.
always, that is already with them.
Milord,
That-
so far as the board is concerned, Milord, we are not against the
They
investigation.
are more concerned with
Milord,
the,
we
with the
are-
money, not.
And
Not
Lordship,
only more.
so far,
Milord,
if I
I am
may,
not concerned with
reply
let
to
the
my,
investigation go on. I am
No,
not
that-
against this.
I know, you are concerned with the money.
Exactly.
Yes.
Yeah,
Lordship,
where
if I
from
may,
do I see?
reply to my esteemed senior friend,
Milord,
representing the board, Lordship, it was the part and parcel
The
of
board
the
has
board.
engaged Mr. Gupta, the board has engaged Mr. Sanyal.
Milord, the court, the question is, in respect to all criminal offences, Milord, investigation takes place. Who has to bear it?
Probably I went to some other way.
I couldn't follow.
Your juniors have followed.
কি বলছেন that's all.
যে আপনাদের পুরো কনফিডেন্টলি সত্যি করে করে পড়ছে সত্যি আপনাদের সাবসিডাইজ রেটে করে
Side judgment. His role is, we will consider that, don't worry.
Yes.
For the money part, no difficulty, we understand. Side the judgments.
Yes.
Mr. Lahiri, the learned advocate appearing for the appellant in MAT 1531 of 2024, submits that he would like to cite certain
চাইলে তবে
declaring the law in respect
For further forensic analysis of this particular data, we have to send a total of 2 sets to each and every forensic analysis teams. So that quantum, at least it varies to almost 200 Lordship, 200 hard disks then.
you
Procuring,
have asked for 20 only.
Lordship, initially we have asked for 20 only, of 4 TB each.
Give it. 20.
I don't have money.
You don't have money.
I don't have money.
My
My only money, my lord, I get is from the conducting the state examination, selling of application forms, nothing else.
Let the state pay the money. State government is responsible, my lord, to carry out the investigation.
That's
Oh.
a different aspect.
কি বলেছি? Let this
Investigation
matter be
cost is
listed
borne
on.
by the
কবে
other-
বলেছি? When?
my lord, lordship fixes any date.
No, we asked you 17, 18, what?
Yes, yes.
19, 20.
2018.
Sukkant Malik Kovacic. 18.
18.
After 16, then it.
দেখো, this West Bengal Board of Primary Education has also filed an appeal being MET 1382 of 2024. Sorry, let's stop now. Challenging the portion of the impugned order by which the single bench directed to recompense the CBI any monetary expenditures likely to be incurred in
ভাই এই সপ্তাহে রাখবেন 9-10
making an investigation. Full stop.
which is being done.
Kindly keep up my point,
All points
including your
agitated
point. Bear the cost. Therefore, police department will be run by the citizens.
now.
CBI
now-
will be run by the citizens.
wider aspect. Why there has been several laws which are enacted. Victim compensation is provided by the state. State is a prosecutor. That's it. It prosecutes any crime which is against this society. Yet he is liable to pay the compensation for such crime. Is it not a double
Here I will say
burden?
only
Someone
only in a situation where
state is not having any application in persons. It's a neutral body. I have heard in one of my judgment that it has no religion also. It's a neutral. It is for the welfare of the welfare of the public. That anything which is in pursuit of unearthing the wrong, crime, or whatever of such nature, which has a large not
because of this reason, Lord, because of this reason, investigation is a job of any sovereign body, any sovereign country. In investigation to find out, to unearth crime. But
prosecution also.
of course, yes, everything. Therefore, my lord, if somebody says that the person against whom the prosecution is being held or the investigation is being held, he has to bear the cost.
I can give you on that. It cannot be. Anyhow, we are not delving on much deep into it. For the time being, as an interim management, we say that.
But the-
we sanction it,
But my lord, this money,
it and then give it to.
my lord, this payment cannot be cannot be sent back to the state. The payment that has to be made here by this order, because state is not appearing before your lordship. State is not appearing before your lordship today.
Consider it, what to do. Yeah, you
My lord,
also
in
have
the
to look at
meantime-
money
Otherwise, your lordships could have
from the
your lordships could have stayed that this part of the order only.
First to give it, let us see.
In the meantime, my lord, they have mentioned the matter. It is appearing next week, my lord, before the honorable trial judge.